Judgment on the appeal Vestergaard Frandsen A against Bestnet Europe Limited.
This appeal concerns the alleged misuse of confidential information. 3 companies, which can conveniently be referred to as Vestergaard, developed techniques, which I'll call the techniques, enabling them to manufacture and sell long-lasting insecticidal nets, LLINs. Their purpose is to prevent the sleeper from being bitten by mosquitoes. A Dr. Skovmand worked as a consultant to Vestergaard between 1998 and 2005, and he played a major part in developing the techniques. From 2000 to 2004, a Mrs. Sig and a Mr. Larsen were also employed by Vestergaard. All 3 of them owed Vestergaard an obligation to respect the confidentiality of its trade secrets. In 2004, Mrs. Sig and Mr. Larsen resigned from Vestergaard and formed a Danish company called Intection, which started to compete with Vestergaard, manufacturing and selling new LLINs under the name of NetProtect. Dr. Skovmand assisted them in manufacturing NetProtect, and in doing so, unknown to Mrs. Sig, he used the techniques. After Vestergaard had issued the proceedings in Denmark against Intection, Mrs. Sig resigned from Intection, and a new English company, Bestnet Europe Limited, Bestnet, was formed, with Mrs. Sig as the sole director and Dr. Skovmand as one of the shareholders. Dr. Skovmand continued the work which he had been doing on the NetProtect product. Vestergaard brought proceedings in England against Bestnet, Mr. Larsen and Mrs. Sig on the grounds that they had misused Vestergaard's confidential information. Mr. Justice Arnold found that the techniques did indeed constitute confidential information and that all the defendants were liable for breach of confidence to Vestergaard. On appeal, while upholding the rest of Mr. Justice Arnold's judgment, the Court of Appeal reversed his finding that Mrs. Sig was liable to Vestergaard for breach of confidence. Vestergaard appealed to the Supreme Court, arguing that Mrs. Sig is liable for breach of confidence, first, under the terms of her employment contract, secondly, for being party to a common design which involved Vestergaard's trade secrets being misused, and thirdly, for being party to a breach of confidence as she had worked for Vestergaard and then for the companies involved in developing and selling the NetProtect product. The Supreme Court unanimously dismisses Vestergaard's appeal in a judgment which I've given and with which my colleagues agree. Vestergaard's appeal fails because of the combination of 2 crucial facts. First, Mrs. Sig did not herself ever acquire the confidential information in question. Secondly, until some point in these proceedings, Mrs. Sig was honestly unaware that NetProtect had been developed using Vestergaard's trade secrets. An action for breach of confidence is based ultimately on conscience. In order for the conscience of a defendant to be affected, she must have information which she has agreed or which she knows is confidential. Or she must have been party to some action which she knows involves the misuse of the confidential information. Given that Mrs. Sig neither knew of the identity of Vestergaard's trade secrets, nor that they were being or had been used wrongly, it follows that Mrs. Sig should not be liable. The law has to maintain a realistic and fair balance between effectively protecting trade secrets and other intellectual property rights, and not unreasonably inhibiting competition in the marketplace. The protection of intellectual property, including trade secrets, is a vital contribution to the law so far as research and development is concerned. But the law should not discourage former employees from benefiting society and advancing themselves by imposing unfair potential difficulties on their honest attempts to compete with their former employers, and it would be inconsistent with maintaining that balance if we held Mrs. Sig liable to Vestergaard. More specifically, the express provisions of Mrs. Sig's employment contract do not help Vestergaard's case, and a term cannot possibly be implied into her contract which would render her liable in circumstances such as those in this case. Secondly, Mrs. Sig cannot be liable under common design as a defendant can only be liable under this head if she shares with others the essential elements which render the design unlawful, and here she did not have the requisite knowledge. Thirdly, the judge did not make any finding of dishonesty against Mrs. Sigg, and indeed there was no basis for making such a finding. It is not enough to render a defendant secondarily liable for misuse of trade secrets by another to establish merely that she took a risk in acting as she did.